It's Madison Kiza, and today we're going to be looking at a recent case which was delivered now in May 2022, which really declared Section 73 of the Divorce Act unconstitutional. Still to be confirmed by the Constitutional Court, but just from a financial planning perspective, how does it affect us if it does affect us? To understand the case that we're about to discuss, which is KG versus Minister of Home Affairs, and I'll put the link and the case on the description below as an attachment. We really have to go back and do a quick snapshot of the history of marital regimes, just to understand how the court arrived at the decision that they arrived on. So in South Africa, we basically have three marital regimes. The first one being the community of property. Basically, it means whatever he brings into the marriage and whatever she brings into the marriage, they share 50-50, including liabilities. So assets and liabilities are shared equally, 50-50. And then the next two are out of community of property. So let's have a look at first the third one. We're going to jump to the third one for now, and we'll come back to the second one because I want you to talk. I want you to remember the date of 1984. If you look at the third one, at the start of the marriage, whatever is his, whatever his assets are, remain his, and whatever his liabilities remain his, and whatever her assets are, remain hers, and whatever her liabilities are, remain hers. And so there's always that separation of estates between the two. And then in 1984, to remedy some of the injustices of the past, we came up with a system where we now said at least, sure, it's out of community of property, but he and she must at least share whatever the assets are and losses that happened during the subsistence of the marriage. Now that obviously came about because of the past. If you look at the third marital option before the second one was introduced in 1984, you had a scenario where wives could be put in jeopardy because if they had to marry and stay at home and therefore not have their assets increase or their estate increase, then they took divorce or death, then they're disadvantaged because their assets or their estate hasn't grown at all. So the case we're going to be discussing doesn't really look at the calculation of accrual systems and all of that. We're not going to go into detail. We're really just doing on a constitutional points, which we'll discuss later on. And so I'm going to, as I discuss, I'm just going to be very high level and just touch mainly on the assets that the couple has and not focus on the deductions and so on. So if we take an example, let's say at the start of the marriage, he begins with assets worth R1 million. That could be comprised of a house, car, whatever his assets are, he's worth R1 million. And at the start of the marriage, she's worth zero. So she doesn't have any assets at this point. And then as time goes, she's a stay-at-home mom looking after the kids and so on. He gets into a business and his business is now worth R9 million. So now that means, let's assume, for example, dissolution of the marriage happens at this point. Now, if he came in with R1 million and now his business is worth R9 million, the total value at this point is R10 million. Now, because she has been a stay-at-home mom, she hasn't accumulated any assets. I'm keeping the facts simple. So she hasn't accumulated any assets, but because she's married in community of property, although he's worth R10 million now through the shares that he holds in the business and so on, at dissolution of the marriage, they're going to share in this total value of R10 million over here. So ultimately, at dissolution of the marriage, he will be worth R5 million and she will be worth R5 million. So it's split in exactly in the middle, 50-50. We share in assets and in the losses. So that's the community of property. Again, I'm not going to touch on things like the benefits and the pros and cons. We're just looking and building on to discussing why the Constitutional Court found Section 73 of the Divorce Act unconstitutional. Okay, so that was the marriage and community of property. Now we're going to jump and skip the second one and go to the third one for now, which is the marriage out of community of property. With the marriage out of community of property, taking the same facts again, let's say at the start of the marriage, he had whatever his SSR, car, house, and they were worth R1 million. Sorry. And then he went into a business, and his business grew to R9 million. So that at dissolution of the marriage, he is worth R10 million. Now, with sticking with the same facts, if she came into the marriage at the beginning of the marriage with zero, and then her estate didn't grow, again, staying at home, raising kids, a homemaker basically, then her assets or her estate hasn't grown by anything. So at dissolution of the marriage, at this point, he walks away with an estate of R10 million, while she still sits with an estate of zero. So because of this injustice, because a lot of the times, obviously, women, especially in the past, would stay at home. I mean, in the past, we had things like marital power over women and so on. Because of those injustices of the past, we decided to come up with another system, which is now the out of community, but with the accrual, where now we can say at least during the marriage, whatever they accumulate, they must at least share. So now, if you look at the third marital regime, which was introduced in 1984 by the Matrimonial Property Act, now what happens is at the start of the marriage, he starts out with assets worth R1 million. Now, it is those assets that we exclude from the marriage. Now, again, he goes into business, and the business grows to R9 million. So from here, let's say the business grows to R9 million, so that at dissolution of the marriage, he is now worth R10 million. Now, she, again, same facts. She started off at zero. She's a stay-at-home mom. She didn't get into business or anything like that. And at the dissolution of the marriage, she hadn't acquired any assets, so she stayed at zero. Now, at least what this system does is to say for the husband, this R1 million will stay his, because that is what he came in with into the marriage. He always had those assets before the marriage commenced, so that is excluded. However, his business is worth R9 million at date of dissolution of the marriage. It is this R9 million that now at least is going to be divided by 2, so that this R9 million could be shared with her. And if you take R9 million and divide by 2, you get R4.5 million. So at dissolution of the marriage, in this scenario, although he keeps his R1 million because he initially came into the marriage with that, and that it's always separate. However, during the subsistence of the marriage, he had a greater growth of an estate by R9 million, while she had none. And because he had a greater growth, the person with less growth can claim half of the difference from the person with the greater growth. So in our case, R9 million, you divide it by 2. Therefore, she, at the date of dissolution of the marriage, she at least has R4 million. So you can at least see in this scenario, we've at least cured the problem of saying, well, during the subsistence of the marriage, the wife did contribute, but to raising the family, being a homemaker. But however, at dissolution of the marriage, she walks away with nothing, which is the out of community of property, which is the third option. The introduction of the marital regime of out of community with the accrual system really tried to solve the problem that was created in the past, where if you didn't want to be in community of property and you chose to get married out of community of property, the problem there was that, looking into our past, we know that women haven't had the same opportunities as men, and therefore generally they tend to be the men tend to be more in a more financially stronger position, and going forward when it comes to jobs, opportunities, and so on. So at least what the marital regime that includes the accrual system tries to correct is to say at least a husband can keep whatever his assets are that he accumulated before the date of the marriage. But that at least now to reach a bit of justice, although the wife has stayed at home, she's been a homemaker. She has contributed into this marriage in order for the husband to be successful, run the business, and so on. So therefore, at least let her at least share in the spoils of whatever the assets are, or whatever the growth of the estates is during the subsistence of the marriage. So I try to remedy that ill. However, at the same time, in trying to remedy that, we had to also be mindful of the right to contract, because there could be many reasons why parties might not choose to be in a community of property marital regime, or out of community of property with the accrual system, and so on. Now, what the law tried to do is to give those parties freedom that if they truly want to still be married out of community of property, so that what mine is mine before and after the commencement of the marriage, then we can have that option. But if you don't want to do that and you want to share on the spoils during the subsistence of the marriage, then at least go for the option of with the accrual system. So the emphasis here was, by having the three systems, at least we're giving parties the right to make a choice to say, no, we want to completely make sure that what's his is his, what's hers is hers, what's mine is mine, what's hers is hers. So we want to completely separate that. So let's give them that option to make. So now what we see, if we put it on a number line, we see that in 1984, 1st of November, the Matrimonial Property Act came into being. Now, this is the act that tried to remedy the situation where you don't just have an option of community of property or out of community of property. This is the act now that introduced the out of community of property, but with the accrual system, because at least this now says that at least women could now, who've been stay-at-home moms, for example, can now share on the growth of the estate, at least while the marriages was alive. So this was great as an introduction of the accrual system that happened in 1984. Now, our law took a position that because there's a bit of a gap now, we need a bit of a transition. Because we know that some people would have not have had the option to take out the or to enter into a out of community or property with the accrual system. Now, at least for those cases of people who were not married in community or property, but were married A and C, in other words, out of community or property, how can we remedy their situation then? Because there are people who find themselves financially disadvantaged or disillusioned with the marriage, especially women, because they didn't have the option of the accrual system. So what the courts have decided to do was that while the accrual system was introduced, in terms of the Divorce Act, they introduced the Divorce Act. They introduced under Section 7.3 a way to remedy those situations. And what essentially this Divorce Act says, or Section 7.3, is to say, we recognize the fact that for people who were married before 1984, before the accrual system was available, they might be disadvantaged, especially women. So therefore, this Act, Section 7.3, says the court has the right, or upon application, the court has the right to exercise its discretion over here, to exercise its discretion in redistributing the assets of the different spouses. So if, for example, a husband was married out of community of property and he amassed an amount of wealth, let's say 10 million rands, and the wife didn't amass anything, if she can prove that she contributed to the marriage, then the court can intervene. Although she wasn't married with the accrual system because the system wasn't available to her, but the court can intervene in making a redistribution order in order to make sure that justice is served. So in a nutshell, Section 73 is in respect of a marriage out of community or property concluded before the 1st of November 1984. A court has a discretion to make a redistribution order to the effect that any asset or sum of money may be transferred from one spouse to another, subject to Section 7.4, 5, and 6. Now, the whole point of Section 7.3, as I've said earlier, is to really help those spouses who got married before 1984 and they didn't have the benefit of the accrual system. Now, just briefly, what does Section 7.4, 5, and 6 say? Again, because we're in a super summary here, I'm just going to give you the essence of it. The essence is that any party approaching the court for the relief in Section 7.3 must make out a case that it contributed directly or indirectly to the maintenance or increase of the estate of the other party during the subsistence of the marriage. I think it's important at this point to stress that Section 7.3 of the Divorce Act is not an automatic thing. So if somebody's married in community property, they're married in community property. If they're married in without the out of community property with the accrual system, that is that. Without the accrual system, that is that. This is an extraordinary remedy. In other words, is to really help out those spouses that didn't have the opportunity of getting married with the accrual system. So the courts will take at face value whatever the marital regime is, but upon application, that spouse who's disadvantaged financially, generally tending to be women based on our history, that she can approach the court to say, yes, I was married before 1984. However, please assist me here. I did contribute to the growth of his assets, and therefore, could you consider a redistribution order for the sake of fairness? So whilst the coming in of Section 7.3 of the Divorce Act could be applauded as a way to transition from a situation where we only had community of property or out of community of property, now we sit with a problem, however. The reality is that women who are getting married today, they might not necessarily be in the right position to actually decide whether to exclude the accrual system. In other words, yes, while they have the capacity to enter into a marriage, so they're over 18, they're of sane, sober mind, and all of those things, so contractual capacity is there. But however, their bargaining power might be compromised, and they might enter into a marriage out of community of property, excluding the accrual system, to their disadvantage. And for this, I just want to share a quick case which the court actually considered in Australia that kind of depicts this scenario. So in order just to paint a picture of what could happen factually, this is the case that the KG case referred to, which happened in Australia, because it came up, how do other systems handle it? So I'm just going to read a quick extract from the case. The court considered that the husband was 10 years older than the wife, in a significantly superior financial position to the wife, while the wife was financially dependent on the husband and pregnant when the agreement was signed. The court held that the wife was at special disadvantage due to the combination of the mentioned factors, and the husband acted unconscientiously when he took advantage thereof. The difference in the bargaining power between the parties was one of the factors the court considered when setting aside the agreement. So there was a classic example where the question of capacity to contract by the wife in these circumstances was beyond doubt. We were fine with that. But the court realized that there is, in reality, this difference in bargaining power, and therefore they could intervene and make a redistribution order, or in this case, setting aside the agreement, which basically said what's his is his and what's hers is hers. And you can see clearly, I don't have to go into it, you can see that from a bargaining power perspective, those facts show that the wife is obviously at a disadvantage, being pushed to sign something that she will not benefit out of when it comes to divorce. Now, coming back to the KG case, to the South African context, You'll remember that I said that the accrual system was introduced in 1984. So that was the pivotal date. That's when the courts or the legislatures in their minds thought that, well, we are giving parties to contract freedom. So after 1984, at this point here, going forward, if you get married and you indeed choose to get married without the accrual system, we're giving parties freedom to contract, and yes, they can opt for that because the accrual system is there where they can share on the assets during the subsistence of the marriage. However, for the people who didn't have the benefits of that prior to 1984, the court has a discretion to make that redistribution order in order to be fair to the wife. Now, the problem is this. Whilst, and this is what the Australian case depicts. Whilst it's true that at this point here, the accrual system was introduced, and like in the Australian case, the wife chose to sign without community of property. But the bargaining power is something completely different, because now if she signs without, so she gets married, like in this scenario, without the accrual system, out of community without the accrual system, based on the bargaining power, we know that she's going to be jeopardized. And the courts in other jurisdictions, Canada and so on, also realize that even in these cases, they've got to be able to intervene and make some sort of redistribution order. So in effect, what our legislation did not envisage is that while these transition requirements in 1984 were made in terms of introducing the accrual system, there is, however, a lag in reality. That even in 1980, after 1984, women were in a disadvantaged position, just like in the Australian case, will still fall into being coerced or whatever the case may be. In signing up for marriage out of community property that also excludes the accrual system. So in those cases, it's not just the people who were married before 1984 who are sitting in that inferior bargaining power position, but it can also be people who got married after 1984 that could be sitting in an inferior bargaining power position. So that had to be. So in our unique case, that in our instance, our courts in terms of Section 7(3) of the Divorce Act is that it can only intervene in these instances and arrive at a just order. So therefore, the KG case said that is not fair. Why can't people married after 1984 at this period here? Why can't these people also approach the courts via Section 7(3) and say, please apply a redistribution order, because the bargaining power, quite frankly, wasn't the same when the marriage was entered into. So in order to summarize how the courts reached its decision, this is a very short summary of it. The courts took into consideration a couple of things and weighed them up. The first one was certainty and predictability. Now, it's very important that when you get married or when you're dealing with people, that you know what kind of marital regime that they're in. For example, in a situation of business. So you need to know who the signatories are. If, for example, it's coming to your property, then both spouses have to consent with dealing with immovable property, for example. So the issue is you don't want a situation where you think the person is married out of community of property, for example, excluding the accrual system, and then later on be worried that some court may make a redistribution order and then find that maybe in your business dealings you don't have enough assets to use as security when dealing with that person because it's actually redistributed his assets to the ex-spouse. So while certainty and predictability is very important for business, the court, however, said, firstly, this is not an automatic thing. Like I said earlier on, if you're married, if you've picked one of the marital regimes, then you stick with that marital regime. this is an exceptional remedy that kicks in to play, as we've seen it play out, for example, with marriages before 1984, before the accrual system came in. However, in taking that into consideration, the certainty and predictability is that we've got to weigh up this against all these other factors. And basically, the court found that in terms of equality, the fact that there was a pegging of a date of the 1st of November 1984, it means that a person who got married before that date can approach the court for a redistribution order, whilst the person married after that date cannot. So from an equality perspective, it doesn't make sense. From a fairness perspective, it doesn't make sense. Also, from a reasonableness perspective, while it might have been reasonable back in the day, in 1984, to say, let's introduce a new marital regime which will provide a bit more fairness, especially to disadvantaged spouses. It made sense at that point. And I think that the judge actually made this in his judgment, and he said, but in 2022, this is obviously outdated now. It might have been a transitional thing back then. 2022, we still know that there's going to be a lag between parties having equal or sort of similar bargaining power in entering into marriages. So therefore, we cannot assist those people only just because they were married before 1984 and forget about the ones without bargaining power that got married after 1984. So there is no reasonableness, there is no logic in keeping this date any longer. And then just in terms of justice as well, if we know that in terms of Section 73 of the Divorce Act, if we know that the court can only intervene in order to make sure that justice is basically served at the end of the day, the person claiming to use Section 73 must still show that they contributed to the growth of the estate of their spouse. So it's not like it's an automatic thing. So if they can show that, therefore justice surely can be reached by the court intervening and saying, hey, listen, just like in a case I mentioned earlier, that the bargaining power was not fair here, and then that the spouse might be disadvantaged. So for the sake of reaching justice, this person has contributed during the subsistence of the marriage a hell of a lot and in a great deal. So therefore, I am, as a court, entitled to make an intervening order. Now, if you weigh these two, you see that the court basically took the view that when issues of equality, reasonableness, fairness, justice, the constitutional basically far outweigh trying to make sure that there is certainty and predictability when dealing with certain parties. And I mean, there's many examples of this in other spheres as well. It's not just when it comes to marital regimes, but the courts will not, if it breaks the constitution, hold parties to that contractual obligation, and it's good that they intervene. So what does it mean for us in our financial planning space? I think in summary, when you go back to the legal tension, while we know that certainty and predictability is important, parties, whether in business or in marital regimes, need to know what kind of status they take. So that is important. And we need to plan based on that and not try and assume what might or might not be. I think it's important that it is only the court, and in exceptional circumstances, that can make a redistribution order based on fairness, equality, and all those constitutional things that we've spoken about already. And even that is not an automatic thing. So it is an exceptional circumstance. So from coming back to our financial planning perspective, we have to go forward with knowing that if somebody says I'm married out of community of property, for example, that is how we deal with it. Unfortunately, we cannot plan beyond that, because we don't even know what the court might come to at that point. So whilst the decision is certainly far more important for divorce lawyers, as an example, from our perspective, when we do financial planning, we still have to take it on the face value, whatever the marital regime is. So I hope that clears it up and it helps. So that's basically the gist of the KG case. Thank you.